point of view. It's one thing to know information, but another thing to know how to actually uh, utilize it in the proper manner and actually put it to use. So we definitely appreciate everybody for coming out today. My name is Troy Smokes. I'm actually my appellation, excuse me, is Troy Smokes, right here from Shechem Exum, which is we call Philadelphia. What we're going to be doing is we're going to start out with the preamble, and then we'll go through and get started today. So I'm going to turn it over. You got it. Right ahead.
Good evening, good afternoon, everybody. Peace and brothers. Peace, God. Blessings, brothers, sisters, God, and goddesses. It's an honor to be here before you, and we're going to just start off with the preamble, then we're going to move along from there. All right? Okay. You can stand up if you like. You ready? We the people.
We the people.
Of the Aboriginal Republic of North America.
Of the Aboriginal Republic of North America.
Asserting our natural Aboriginal rights.
Asserting our natural Aboriginal rights.
As the oldest recorded.
As the oldest recorded.
Aboriginal Indigenous peoples of the Americas.
Aboriginal Indigenous peoples of the Americas.
Consisting of Aboriginal Union.
Consisting of Aboriginal Union.
Of Indigenous peoples.
Of Indigenous peoples.
Living in accord with natural law.
Living in accord with natural law.
The law of our ancestors.
The law of our ancestors.
Do hereby recognize.
Do hereby recognize.
All nationals.
All nationals.
Of the Aboriginal Republic of North America.
Of the Aboriginal Republic of North America.
As a unified community.
As a unified community.
Establish our divine right to self-rule.
Establish our divine right to self-rule.
In common defense.
Of
our nation. A complete unified will.
A complete unified will.
For progress and prosperity.
For progress and prosperity.
By and for our people.
By and for our people.
Establishing justice.
Establishing justice.
By way of natural law.
By way of natural law.
And equality.
And equality.
And complete autonomy.
And complete autonomy.
As a nation.
As a nation.
Ashe.
Ashe. So just real quick, I apologize. I'm just trying to quickly get started. Brother Rafiq is actually one of our. One thing I always tell people: pull out. Not only that, because the note that you take, that they had, still passed down who you are, and it continued. So we wouldn't be like, well, who am I? Where am I from? Am I actually from the continent? Did I come over here prior to? Was I born here? I mean, what is this? A lot of us are confused with that. And it's because we are not holding the information. Don't trust someone else to hold it for you. You get it. You hold it, and then you pass it on. So with that, I introduce you, Brother Rafiq.
And again, it's a great pleasure to be here before you. Very honored to be in your great, glorious presence. And today's presentation is going to be on taxes and the examination and analyzing of U.S. tax laws. All right? Now, when you examine, well, the first place you need to start when you examine and analyze U.S. tax laws is Title 26 of the United States Code. That is considered the Internal Revenue Code, as well as Title 26 of the Code of Federal Regulations. That is probably the best. I think that's the best place to start. Also, a lot of information is gathered and placed and lodged with a lot of Supreme Court decisions with regards to taxation. Okay? And let me add this. Give you all this disclaimer notice. I am not an attorney. I'm not a legal authority. I absolutely do not give legal advice. If you're seeking legal advice, it may be wise for you to seek competent, effective legal counsel. All material presented in this presentation are presented for educational and informational purposes only. Y'all hear me back there?
Yeah. Good.
That is
Okay, that's good. All right. All right. Revelation 1. That's for the Bible thumpers. All right, 86 CGS. CGS is Corpus Juris Secundum. Corpus Juris Secundum is a Latin term which means body of law. It is a great source for legal information. If anybody has any legal issues, this is a great resource. Corpus Juris Secundum. And, well, here's what they say about territories with regards to U.S. With regards to the U.S. That's 86. Corpus Juris Secundum. Quote: the term territories generally referred to the political subdivisions created by Congress and not within the boundaries of any of the several states of the Union. More clarification will be added as we move along. But basically, what they're basically saying is Congress do not have control over any territory outside of the U.S., which is essentially the District of Columbia, Guam, the Commonwealth of Puerto Rico, the Virgin Islands. More clarification is going to be added as we move along, according to their law. I didn't make it up. It's what they have on the books. Okay. This case law is from a case law in 1949, and let me quote it. And matter of fact, all of this stuff is in y'all the handouts. So y'all should be good. All right. All right. It is well established. It is a well-established principle of law that all federal regulation applies only within the territorial jurisdiction of the United States, unless a contrary intent appears. This is Supreme Court case law. That basically means whatever is passed in D.C. only applies in D.C. Now, I'm going to show you how to read this case law. See Foley Brothers, Inc. versus Falardo. You see that three? Now, when you look at case law, when you see that 336, that means the volume. When you see that U.S., that means the case reporter. That's U.S. Supreme Report. And you see that 281, that's the page number. So when you go to the law library, they have a section for U.S. Supreme Court reports. And then you just go to volume 336, you just turn page 281, and Foley Brothers versus Falardo case will appear. That's how you look it up. Now, sometimes they won't even give you the name of the case. They'll just give you the numbers, 336 U.S. 281. Sometimes you'll see that. 1949 is the year that the case was rendered. So that's how you read. That's how case laws are printed out. That's how they read, and that's how you locate them. Right? You have the case name, the volume, case reporter, the page number, and the year. And sometimes the numbers, the volume, the case reporter, and the page number will do. All right? Sometimes you'll see it that way. Okay, we're going to go to some more Supreme Court case law. Okay, we're going to go to the United States Supreme Court stipulated in Caja versus U.S. What is that 152? What that 152 stand for? What is that? There you go. How about U.S.? What is that?
Case report in court.
There you go. There you go. You said 211.
Page number.
There you go. And how about this parentheses, 1894 parentheses?
Year.
There you go. Go ahead. You can ask the question you want. Go ahead.
Okay, the volume. Volume falls under category of cases under that particular.
Absolutely. They have a whole list, a section of United States reports with a whole number of volumes of just those reports. But all the cases, that's a case report. Okay. And so they have so many case reporters. You'll see something that say A. Now, take the U.S. out. They have something that'll say something like A to D. That is Atlantic Reporter. That's usually on the East Coast. Atlantic Reporter, second series. Then they had the volume number before, case number after. So how to get it. Then when you go to the law library, you go to Atlantic Reporter section, and you just go to that volume and that page number, and you got the case.
When it says U.S., is it U.S. Supreme Court?
Oh, but yeah, no, that's the United States.
That's the
So
United States.
he's going up against the United States.
Okay.
The Sky High going up against the United States.
Okay.
That case. And it, 152 U.S. That's the case reporter. That's the volume of the case reporter.
But then there's another U.S.
Well, yeah, that's the case reporter. Now you talk the case reporter.
Okay.
He's going up against the United States.
Okay.
Sky High going up against the United States, and it's cited. This is where you can find that case.
Right.
That's all it's saying. All right. All right. Here's what it says: the laws of Congress in respect to those matters outside of constitutionally delegated powers do not extend into the territorial limits of the states of the Union, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. D.C., Commonwealth Puerto Rico, Guam. Y'all start to get the picture. All right? Yes, sir. Ask any question you want, please.
Question. Relative to the states being federal enclaves, how does that stop it how does it stop it from being within that jurisdiction?
Because if it only depends is if it's enclave is basically a possession of the U.S. District Court, but this don't belong to the U.S. This will be considered in the purview of the Commonwealth of Pennsylvania, not the U.S. It has no authority here. You understand? Falls within the federal jurisdiction. Any more questions before we move to the next slide?
We suggest that all jurisdictions outside of the so-called United States are Commonwealth jurisdictions.
No. Like, so you have your states. You have your state from, we start in alphabetical order. From the state of Alabama, from the state of Alabama all the way to the state of Wyoming. It's not considered within the territorial limits of Congress. The Congress don't have exclusive jurisdiction. That is only within the District of Columbia and the U.S. territorial possessions, federal enclaves, and insular possessions. That's it. They're basically saying, nope, this don't have any force and effect outside of our jurisdiction. That's all it is. They just basically come right out with it. The laws of Congress in respect to those matters do not extend it to the territorial limits of the states, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. Got some more case law, y'all. It's gonna be short to the point, and most of these case citations are in your handout. All right. This is a quote from U.S. versus Spillar. This is cited in 338, U.S. 217, and 222. All right. Quote: there's a canon, there's a rule, right, of legislative construction which teaches that Congress that unless a contrary intent appears in legislation is meant to apply only within the territorial jurisdiction of the United States, the District of Columbia. So, if they say this is federal jurisdiction, it's going to extend outside of the federal jurisdiction. If it's passed by Congress, it's going to extend outside the federal jurisdiction. I want Pennsylvania, state of New Jersey, state of New York, whatever state you want. It don't extend outside of those particular federal enclaves. All right? Y'all know how to read the case, though. Y'all know how to get cases now. Ooh. All right. Revolution 5. Oh, this is mean right here, y'all. All right. But the power to make rules and regulations respecting the territory is not restrained by state lines. nor are there any constitutional prohibitions upon its exercise in the domain of the United States within the states. And whatever rules and regulations respecting territory Congress may constitutionally make are supreme and are not dependent upon the situs of the territory. This is the Dred Scott case. A lot of people are familiar with that case. This 60 U.S., page 393, 509, 510, 1856. Now, this is highly important in regards to our people. Now, I think this is the case with the brother. I think he escaped of his enslavement. He went to don't quote me on this, but if I'm not mistaken, I think it was the state of Missouri. Well, the state of Missouri didn't have any slavery within its state. But the state that the brother left from, escaped from, they had that. So what the Supreme Court is basically saying is, there's nothing we can do about this. We had the power we have is supreme in our jurisdiction, but not outside of that. Man, drop the check. Yeah. We're gonna go further. Oh, now this is the Senate House. This is the Senate House legislative intent that was quoted by President at that time was William H. Taft. This is in June. This is on June 16, 1909. And here's his quote. This is before the passage of the 16th Amendment, which the IRS usually rely on to force their taxation and their their scheme to deprive you of your property. Right. This is a quote from President William H. Taft. I therefore recommend to the Congress that both houses, by a 2/3 vote, shall propose an amendment to the Constitution conferring the power to levy an income tax upon the national government without apportionment among the states in proportion to population. He's basically stating that taxes are only for public officials, federal government officials, the national government. That's it. Leave the states out of this. We're going to go no further. There we go. Okay. No. We're gonna leave this. We're gonna go back to that. Okay. For the purpose of federal income, estate, and gift taxes properly accepted under paragraph 1, that's 31 United States Code subsection 321 D1. We're going to go back to that. All right. Shall be considered as a gift or bequest to and for the use of the United States. That'll become clear later. But anybody have any questions with regards to this slide? Ask any question you want. That's right.
What's in the agreement?
So we are voluntarily.
You can't take your gift back without doing something else.
But what do it mean when the term says get request?
Huh? No, it says bequest.
Mm-hmm.
Bequest is a gift. It's bequeath. You're giving something to somebody. Now they depending on that. You said you would give it to me. You stated
Well,
under.
I only stated I was going to give it to you because I didn't know what I was stating
Oh,
when I
oh.
signed those papers and when I went to the job. Yeah, coercion.
Well, that's
I'm sorry, is that?
I'm gonna say that's misinformed consent. But I wouldn't necessarily say coercion per se.
Okay.
But we gonna get deeper into that though. But
Okay.
we on something though.
They allowed me to do it.
We on to something. Yeah, they got they gave options. Okay.
Oh, okay. Gotcha.
So if you didn't contract, you didn't do it properly.
Right.
You can ask a question. If you didn't contract properly, you're on the hook for it. We need that gift, y'all. We got to get that up.
And when I took the job and I sat down in there, they put all these papers in front of me saying, this is for your check, this is for this is for that. And how many deductions you got.
Wow.
It really was. None of it.
It's,
Okay.
that's a good one. Please.
Okay,
All right.
so what I'm
Yeah.
saying is, I ever saw that piece. I kept a copy of the application that I'll have to share once I look it up. But
Very shrewd people. Man. Full disclosure, y'all. This is my first ever PowerPoint presentation.
Oh, you doing excellent.
Never done a PowerPoint presentation in my life. So, but I'll
but
read
you have the
it for you.
information.
I do have the information. Y'all got the information too.
Right.
That restricts the public. They always have to give you your way out. Now, it's not their job to tell you your way out.
Right. Process.
No, well, there's a legal maxim that says ignorance of the law is no excuse,
No excuse. Yes, sir.
and they hold you to that.
Yes, sir.
Now, I think this is very demonic and very evil. In my personal opinion, but you're gonna hold us to it. Okay, so let's go a little further. Okay, so right there, that's in y'all pamphlets, that's in y'all handouts. But 26 United States Code, subsection 6013 G4A. Now, whenever you file a tax form, you have made an election to provide a gift to the United States. All right? But there's always a way out there. Okay. Now, let's consider an election. Right? Now, you can't just say, I ain't paying out taxes no more. There's certain measures that you have to go through in order to address those specific things. So here, now that it's revealed in this particular statute, this code, this section, termination of election. Now they hit it under joint filers. Oh, no, they make it look like it has everything to do with joint filers, but no, it has to do with individual taxpayers.
Yeah, that's
Oh, these people are shrewd. Check
that's
it out,
evil.
y'all.
That's pure evil.
But check it out. Check it out. Okay. 26 United States Code, subsection 6013 G4A. 4. Termination of an election. An election under this subsection shall terminate at the earliest of the following times. A. Revocation by taxpayers. If either taxpayer revokes the election as of the first taxable year for which this double speak. As of the first taxable year for which the last day prescribed by law for filing the return of taxes under Chapter 1 has not yet occurred. That basically means if you revoke the election before April 15th, then you have revoked the election for the following years.
Following year.
Still got
following
years.
25 years.
Yes, if you did it before April
Plural.
15th, then you wouldn't have to do it for this year.
Okay, that's single.
That's single, absolutely. But if you do it, if you decide to do it today,
Gotcha.
if you carry it over to 2016,
Oh, thanks.
forever. Yes, sir.
Make sure I'm very clear.
Absolutely.
Okay, so for instance, let's say I had not filed taxes for maybe the past 3 years, and then I go and I file this. I know next year when, because I'm a tax accountant, so I do taxes for people.
But
You ain't got to do what you
People
got
want
to
to
do.
do the election. That's up to them.
Yeah, that's right.
Makes sense.
So, and I work with white people.
Even better.
Cash has no color. So when it comes down to it, if I'm filing a tax for next year is going to cover 2015. So if this ratification goes in, let's say we all did it today.
Right.
Would that cover for us not filing for 2016? You say you have to file for 2016, and then it doesn't cover for 2016?
No. It won't cover for 2016.
Wouldn't?
No, if you do it today, before April 15,
Right.
then you good for 2016.
So you wouldn't have to file your 2015 taxes.
Now,
Understand what I mean?
Yeah, I know what he's
2015 is filed in 2016 because the tax year ends December 31st.
Correct.
So everybody gets their W-2s, 1099s on between January 2016
Right.
to January 31st, 2016.
Correct.
If they bring it to me and I file those taxes for the year of 2015, but it goes in as 2016, but the year is actually 2015.
Right.
So we're always a year behind.
Right.
So if you do this, does it cover 2015?
No.
So so the election stops. You're 1 year ahead with the election.
Yes.
And then did you have to file in 2014
Well,
in order to
no.
take
Anything that you had prior, you had to deal with that.
So is this how you have to do this every year?
No.
Or you
No.
just do it
Okay,
once
Once
you
you revoke it,
That's it.
we're gonna get to that.
Okay.
We're gonna get to that. It's all up in
Yeah,
there.
because I was sensing
We gonna
that
get to
that's
that.
what he meant, but
We're gonna get to
I
that.
kind of jumped ahead.
It has to be done a specific way. It's simple, but this is what I would encourage that y'all do. Encourage that y'all read the pamphlets thoroughly, and just go through the information and analyze it and examine it carefully before you interface with these people. Because you need to know how to properly interface with them and communicate with them. Right? Now, when I said mine, they didn't say, yeah, your tax liabilities are over. They say, oh, we received your correspondence dated on such and such a date. We're sending it to so and so for processing. Thank you for your correspondence.
That was it.
Okay, so my nephew, he worked this past summer.
Right.
His mother had him sign these documents
Right.
that I told her don't.
Right.
However, he did. So if this was done right away for him,
If this was done before April 15th, he would have been good.
well, he worked in the summer, so there's no way he could have done it before April 15 because he had never worked.
He's on the hook.
Okay, so he's on the hook.
He's on the hook for
But to get him out of that,
to get him out of that.
because he's only 16, so
He's not responsible for taxes at age 16.
they still take taxes.
Really?
The
Yeah,
children
they
do.
take taxes.
Yeah,
The
they
children
take
do take taxes.
Yes, they
But
do.
it usually don't be enough for them if they don't try to file.
It's just, now they don't have to file. The mother has to file,
Okay.
but children actually pay taxes. Yes. If you check his, if you look at his check, his gross pay was 200. His bring home pay was 130.
Oh, yeah, they take that. Okay, now you hear this?
I paid taxes when I worked as a summer job as a teenager, and that was what, a long time ago.
Yeah.
Okay, so they couldn't take the tax.
You know what they're gonna tell you. Ignorance of the law is no excuse.
Yeah.
I understand that, but my thing is that, again, and this is why I said earlier,
Right.
take the copious notes, because a lot of our children are falling subject to this, and just doing summer jobs. I mean, based upon even their codes, are children supposed to pay taxes?
Oh, I know.
Well, how would that child be taking tax? How would he take care of that?
Well, he had to have tax prepared. But
So,
but
it's regulation.
if you're in the system and if you're paying taxes, there are remedies for that as well. You know why? Because they consider you a business.
Okay,
A person that's right. A person doing business in the District of Columbia. And you said yes, that's who I am. Now, are you familiar with Schedule 1040C, brother?
No.
Oh, no, not people. Schedule 1040C. Well, that's what you should be following if you're in the system. And it's for sole proprietors. Now you can write off your mortgages, your car notes, your utilities, with that particular form, absolutely. Your gas, travel expenses, your food, your entertainment. Oh yeah. Remember you live in the system too. Sometimes it's beneficial.
I am. I'm sorry. Yeah,
Yeah. 1046.
Yeah, but you know what? A lot of times, what I find is that I've seen them revoke people's election on that. They'll literally tell them.
No, but that's not considered an election though. That's not considered an election.
I get what you're saying, but
That's not an
I've
election.
seen them actually take that away from people. Really tell them no, we're not accepting that. You need to produce all your receipts.
Well, yeah, you want to have those receipts. Yeah, you want to have those receipts.
I've seen people with the receipts that have still rejected. Yeah.
That's an issue now. Okay, the next I'm going to revoke the election and tell me where to go. Okay, so we go to the next slide, but this is going to go into depth. All right. Okay, check this out. It's 26 United States Code, subsection 6013 G6. Check this out. If any election under this subsection for any two individuals is terminated under paragraph 405 for any taxable year, such two individuals shall be ineligible to make an election under this subsection for any subsequent taxable year. Basically saying when you revoke the election, you can't even pay us no more.
Sure.
Mean any tax, foul. Any foul on taxable year.
So they can't receive it from you after you.
No, you can't. No, you can't even hook them up no more.
Will they automatically stop taking those taxes?
Well, if you communicate
file
with them, you communicate with the I file nothing. You communicate with them properly. Okay, guys, here, look at here. Here's a copy of my verification of election. It was sent to you on such and such a date. You received it at such and such a time. And the taxes are only considered for resident aliens. Resident aliens of the United States.
Okay.
District of Columbia.
Well,
Ask any questions.
I know if they tell me in District of Columbia, then okay, I know I shouldn't be involved with that anyway. But I don't understand the resident alien.
Resident alien? That means that you reside in the District of Columbia.
What if you live in a district and reside in a district?
Well, that's good. You better use another address. You better get in Maryland. You better get in Maryland.
Real quick.
Yeah. The district.
That's why they say
Congressional jurisdiction. Yes. Absolutely. Yep. And they got you down as a sole proprietor. They can only tax corporation. But they have to put you down as a corporation because that's It's the only entities they can tax. Unless you say, I'm an individual and I want you to tax me as a corporation, say, okay, well, you made the gift. You made the election.
Now, even though this is on the federal level that we're speaking of, what about on the state and city?
Well, the state level, that's all that's all.
Besides the Black's Law, what other references can I use to study?
Well, I think this is the law. This is what you want to use.
You say the city.
Title 26. They only They only operate according to their statutes and implementing regulations, which is at Title 26, United States Code, and 26 Code of Federal Regulations. Right? Which is only applicable in Washington, D.C. But we say we're resident aliens. So we're resident aliens of the states of where we live in. And we're residents of the District of Columbia.
Both, yes.
No, that's what we say. Yeah, you're a resident alien of the state. But you're a resident of the District of Columbia.
If you make the election.
If you make the election. But most everybody make the election. You make the election means you file tax forms.
Right.
You sign under penalties for yes sir, brother in the back.
I think it's the slide prior.
Yes sir.
Right, you basically said that you were saying that it's because you're no longer obligated to pay for subsequent.
Oh no, that's not case law.
After you file the election.
That is the code right here.
And is there any case law interpretation for that you come across?
Well, the case law that I read previously that states that the federal jurisdiction doesn't have any power over the states of the union. And the legislative intent of the 16th Amendment, because that's they go to constitutional amendment. Yes, ma'am. Yes.
I was asking about
The city, yes, the city municipal taxes. Yeah, no, you have to pay that.
Yeah, that's my main
That's your main problem. Is that based on your job, or that's based on the contract? Oh, okay. That's another conversation. It's a whole other conversation.
So independent contractors have no way out.
Yeah, corporate entity.
Okay.
So they're responsible for the corporate tax.
What was that question again?
She asks about the responsibilities of corporate entities. She's a private contractor. It's an independent contractor. So yeah, but it's a corporate entity.
And those
So what kind of entity you have? Do you have LLC? Incorporated? What kind of entity is it?
whether I'm a sole proprietor or not.
Yeah.
I guess I'll consider it sole
The
proprietor.
sole proprietor is probably one of the worst. Yes, it's Schedule 10. What? Yeah. No. That's
around five.
that's federal. That's federal. Yeah, sole proprietor is one of the worst business. That's the least protected because
1065, right?
Huh?
I think it's 1065. That's 1065.
I'm not exactly sure. I'm not exactly sure.
So it's better to be an LLC.
It's better to be an LLC because the business is responsible as opposed to the individual. If you're sole proprietor, the individual is responsible and liable for any liabilities that they render upon anybody else.
But being an LLC.
LLC, the actual business is responsible as opposed to the individual owner or the member.
Would you suggest that over being incorporated?
Yeah, it has more tax benefits. Certain way you can maneuver, certain tax benefits, certain if you travel, then you write all that stuff off, so has its benefits. But you won't be responsible, the business will.
Right.
So you want to be careful of the access of that business. You want to keep it to a bare minimum. You would put it in a trust or you do all kinds of other things. You want to protect your assets. Yes, sir.
Sometimes as a contractor,
Yeah.
you're not necessarily a LLC or any of that. Sometimes it's just that you're operating as a contractor. So, like for instance, let's say you have a gym and I'm a massage therapist. You may contract me to come in
Right.
to work at your gym, but I don't necessarily have a quote unquote business.
Right.
So, in that regard, I think that's
Well, that's you consider sole proprietor.
okay.
No, she's really not so proprietor. She's what you said. She might not have found that.
Say it again now.
She's what Troy is saying.
Independent contractor.
Yeah.
Sole proprietor.
Most independent
But she's not.
contractors
But
sold
she. What,
proprietor.
in other words, what you were saying is she's not registered as that type entity.
Right.
Because you can actually incorporate as a sole
You
proprietor.
can, but by default, they're going to consider you a sole proprietor. Move forward. Okay, check this out. Okay, Title 26, United States Code, subsection 7408D. Did you get the handout? Did you get the handout? Yeah, this is my uncle. This is the one who inspired me. This is the one who told me about Marcus Garvey when I was a youngster.
There you go.
This is the one that taught me about the free branch system of government back in the late 80s. Well, I didn't know, didn't want to be told. Yeah, this is the one that told me about the Nation of Islam. This is the one that told me about ISIS, Ali Muhammad. This is the one that got me here.
Yeah, OG, go ahead,
This
Elder.
one.
So you passed it on.
So, absolutely.
You passed it on.
Absolutely. If you look at him, you can tell I look like him. So, all right. That's my mother's oldest brother. All right. All right. So 26 United States Code, subsection 7408D. Citizens and residents outside the United States. Now watch this language, y'all. If any citizen or resident of the United States does not reside in and does not have his principal place of business in any United States judicial district, such citizen or resident shall be treated for purposes of this section as residing in the District of Columbia.
They went to all it back.
Huh?
But she's in
No.
if you don't claim.
Manipulated the language.
No, they're basically saying
You don't claim.
if you don't, if you don't reside in the United States, but you're a U.S. citizen, then they're gonna treat you as if you live in the District of Columbia. So if you live in
Where else?
Acapulco, you're still a U.S. citizen, they're gonna treat you as if you live in the District of Columbia.
Okay, so that's where it becomes important.
Central place. District of Columbia, yes. So you live in that district, man.
Does it say what year? I see the code. Does
No,
it
that's
say
just the
what
code.
year
That's just the
it
code. That's just the
enacted?
implemented statute of the code. That's in the code. That's the body code.
Codes change.
They do change. They do change periodically. They do change periodically. But this is what they operate off: implementing code and regulation. And if it's a court matter, then the Supreme Court decisions, previous Supreme Court decisions, have this power with regards to any particular court issue. All right. Now, this language is very convoluted. This kind of turns you off from legal language and legalese. Look at this. Check this out. All right. It's 26 United States Code, subsection 7701. It's the definition section. Subsection 26, trade or business. The term trade or business, they got that in quotes, includes the performance of the functions of a public office. They're basically telling you, when we went over the fact that they can only tax government officials, that's who they're supposed to tax.
So they're naming,
So they're naming it. Oh,
they're
wow.
redefining,
They're catching it.
right.
It's saying you trade.
Catch
So
22.
So you gauge the trade, and then, yeah, absolutely, because now they're listing you as a sole proprietor, all capital name, without your knowledge. But you made the election. So they do got your permission. And they have it under the pain, the penalties of perjury.
Wow.
They have it. Say it again. Repeat that.
They have your signature and your consent under the pains and penalties of perjury. So there's a clause in the tax form that says, I understand this so-and-so form, and I'm signing under the pains and penalties of perjury.
My Lord.
Oh. That's how they get you. We out though. Okay. We're gonna give y'all some extras though. This is gonna get. Hold on, no, I didn't go to that. Okay. All right. Subsection of the same code. Subsection 5011C. The term includes and including. Watch this. When used in the definition contained in this title, shall not be deemed to exclude other things otherwise within the meaning of the term defined. Now, what do that mean?
Then the meaning of the term.
If they didn't redefine the term, it can only mean what it means. Why don't they just have so and so? It's total double speak. Meant to throw you off. But trade of business, this is the trade of business. They said it includes the performance of functions of a public office. It didn't say anybody engaged in LLC, sole proprietor, incorporation, none of that. Man. All right. Okay. We went through this before, but we're going to go through that's 31 United States Code, subsection D, 1 and 2. It's going to make it crystal clear. The Secretary of Treasury may accept, hold, administer, and use gifts and bequests of property, both real and personal, for the purpose of aiding or facilitating the work of the Department of Treasury. Gifts and bequests of money and proceeds from sales of other property received as gifts or bequests shall be deposited in the Treasury in a separate fund and shall be dispersed on order of the Secretary of Treasury. Property accepted under this paragraph and the proceeds thereof shall be used as nearly as possible in accordance with the terms of the gift or bequest. Estate and gift taxes, property accepted under paragraph 1 shall be considered as a gift or a bequest or to or for the use of the United States.
What is a bequest?
Bequest is basically your gift. It's your gift.
Why do you say this?
It's the same thing. It's double talk. Bequest. You give something. You're turning something over. Something you're turning over. Something you're turning over. Yeah. So it could be in the state. It could be something from the state. You say, okay, I want this to go to the federal government.
So how did you deal with this language? Just keep reading it?
You really had to get used to it.
Yeah.
But you want to have somebody explain certain things, certain terms. It gets real good. It's a lot of double talk. But the more you read it, you're gonna be reading all of this. You're gonna be reading other things that makes things a whole lot clearer.
Exactly.
Constitution, the Bill of Rights. This is Article 1 to Article 10 of Bill of Rights. They say the first 10 amendments, but it's really Article 1 to Article 10 of the Bill of Rights. So we know gift. Now we know that federal income taxes are gifts to the government, gifts and bequeaths to the government. Check this out. So Title 26. Now y'all want to take this down because it's not in your pamphlet. Title 26, United States Code, subsection 7806B. B as in boy. No inference, implication, or presumption of legislative construction shall be drawn or made by reason of the location or grouping of any particular section or provision or portion of this title. That's Congress saying, we getting out of this thing. We ain't got nothing to do with this. So it wasn't passed by Congress, that's what I'm saying. All right? But we're going deeper. Nor shall any table of contents, table of cross-references, or similar outline, analysis, or descriptive matter relating to the contents of this title be given any legal effect. They're saying this is not the law at all. But you made the election.
Right, if I signed to volunteer, if I signed those papers.
You made the election. It's a contract. Nobody can impair the obligation of contract. That can be cited at Article 1, Section 10, Clause 1 of the United States Constitution. Article 1, Section 10, Clause 1. No obligations or contracts can be impaired. And check this out. The preceding sentence also applies to the side notes and ancillary tables contained in the various prints of this act before its enactment into law. Now, how can it be law if it has no legal effect? That's right. The Congress say, nope, we getting up out of this thing here. It has no legal effect. Don't even presume that we even passed this. They say no inference, don't even infer, don't imply, or presume that the legislature passed this particular title. Against them, that's it. Don't right here. No, it was on the law, no excuse. So if they put one before me, I say, okay, the lecture was made on such and such a date outside of the court. Example 26 United States Code, subsection 1613 G4A. Get a copy of my paperwork. Now, if the job act like they want to take some taxes out, the job is on the hook, not the IRS. Right. Because there's a certain form that you have to turn over to the job in order for them to take the taxes out. That's right. Because you explicitly stated on the W-4 form that, okay, this don't apply to me. You're not allowed to take anything out. I'm exempt from any withholding.
What is the job itself as 3 years?
Well, where's the central place at? Where's the central? Oh man, see, if it's in the District of Columbia, I wouldn't even deal with it. Like Metro, if Metro, I would just deal with 1040C. Just go that route. Go that route. Right. Yeah, you don't want to be. Yeah. You don't want to be doing battle from on that level. If it's Metro, I'm gonna get a job at Metro.
You gonna get a job?
Yeah, I'm gonna get a job at Metro. I had a daughter, so
yeah,
I had to move back up. Oh yeah. Okay.
You said Metro.
Oh yeah. No, we'll talk later.
Yeah.
Somebody stuff I worked on down there, and he's pretty happy.
Right.
All right. So that's the end of my presentation, y'all.
Whatever happened to your job?
My phone.
Yeah,
My phone was at home.
yeah, I'm just saying. Did you complete the exam?
Well, actually, I don't work, but I'm going back to work. So when I go back, that's what I'm presenting with. And see, I'll be prepared. If the job want to take something out, I'll be prepared to handle it. It won't be me in the IRS no more. It'll be me in the job. Oh, you took this out? Did you have permission to take this
So
out?
the form that you sent to the IRS, how did that work out?
It's not. You just give them notice. You just give them notice. Put it in a simple affidavit form. Yes, sir.
What if you have a scenario like that, right?
Yes, sir.
Where you submit the proper documentation to your job,
No. You want to send it to IRS first.
correspond with both.
Okay, cool. Yeah.
And the IRS instructs your job to do this, contrary to what you tell them to do.
Then you go after the job.
You still just go after the job.
Because
Now, when you go after the
they,
job, what are you going after them under?
oh, well, you're going after trespass. Impairment obligation to contract. Right?
So it'd be a breach of contract.
Absolutely. There's no
Action that
contract.
you've been
There's no contract for you to take this out.
taken. So would it be more so a breach of fiduciary duty?
No, they're not a fiduciary.
So then, what's your cause of action for this?
I told you,
Trespass?
Trespass, right? Illegal seizure, right? Violation of the rights without due process. I mean, you can tack it on. The deprivation of rights under color of law. If you show me that this is the law, I'll pay everything you want me to pay you.
I'm just looking for clarity.
Yeah, absolutely.
Because,
Yeah,
you know,
you get deprivation of rights, conspiracy. But the IRS ain't gonna come and say, we ain't tell them nothing. Because they don't give you the name of the individual in the IRS that told you to do it. See, because when you ask them, they say, okay, the IRS told us to do this. Okay, well, who in the IRS told you to do it? Show it to me in writing.
they're not gonna do that.
Oh, great.
I know that.
That's even better. That's even better.
What court? See, I guess my biggest thing is you're seeking redress
Right.
in a quasi court.
No,
So you're
right.
going to the district court, I'm assuming, to get money.
Yeah.
So the same thing that you're claiming that you don't have jurisdiction. You have
No.
jurisdiction.
No, I'm not. I'm not. No. I'm talking about the job now. It's me and the job. I'm not even talking about the IRS now.
Understand?
You took something that belonged to me and you didn't have a right to take it. So show me that you had the right to take it, and also you had to give me the verified, authentic documentation that verifies that so and so told you to take it. They're not going to be able to prove that.
I agree with that.
Yeah, but if it's done right, you got to do it right. You need to know how to prepare pleadings to the court. You don't have to argue. You state the facts, show your evidence, state the law, you shut up. Here's what you did. You didn't have a right to do it. Here's the law.
So I guess I'm not looking for like you could either do this or you could either do that. Like I'm looking for a specific solution. Like if they're violating a particular right that you're afforded, you have the evidence to substantiate that. It should be a particular. All right, but it shouldn't be either this or you can do that. It should be something that you can do specifically pertaining to that contract or no contract that they're doing against you. That you go against your job. That's all I'm
Hey,
saying.
you have to go to the job.
So if it's color of authority against the job, then it's that.
It's color.
If it's trespass against the job, then it's that. So I'm just looking for, you know what I mean?
You have constitutional breaches. You have statutory breaches.
Just because
Punitive damages.
a while back ago, me personally, I had the same. I was working for Verizon Wireless. Right. Same situation. Now at the point in time, I took law masters, but I wasn't competent.
Right.
Right. I did color of authority, so I went through the whole procedure.
Yeah.
All right. I I went to the EEOC, right, submitted my complaint, right. No one wanted to touch it, right. They gave me my right to sue, right. I initiated my suit. And at the time, I was insufficient with apparent pleading, right. So they got me on 12B6.
Absolutely.
You know,
Yeah,
so and I never picked it back up.
First state claim power, what you legal.
Yeah. So I guess I was just looking for clarity of the facts that you got to assert.
Here's the clarity. Here's the clarity. Say if you file a case, right, against somebody. You don't want to say you violated this, you violated that, you don't say that. You can say that's the conclusion of law. I get that every time. And lawyers have a way, they fall for a hook, line, and sinker. They always do it. You state the facts. You did this. Here's the facts to support that. You did that. Here's the facts to support that. You did this. You did that. Here's the facts. Here's the law. You have an affidavit of support. Now you have your facts to support everything that you have just laid out. And you haven't made one conclusion whatsoever. Now, they're not going to be able to controvert that. If you do it right.
Correct.
It's got to be done right.
So I guess it's more of an understanding on my part. What are the elements that they're looking to support that particular cause of action?
Absolutely.
I guess that's what I'm looking for. Because I deal with specificity.
Yeah. Absolutely. I'm so glad you know specificity. You're absolutely correct. You want to specify. So you don't say, you committed fraud against me. You don't do that. It has to be stated with particularity. Correct. So there's certain elements that have to be met. Right. If you're making a claim for fraud, which is misrepresentation. So, oh yeah, you falsely advertised so and so and so and so. Boom. Here's see exhibit so and so. It's that simple.
Okay, so you just define, put in facts.
With the elements. The elements of fraud is misrepresentation.
Okay, the elements of whatever it is.
Scienter is basically knowledge of the fact that you did so and so. Right? So you got misrepresentation, you have scienter, you have the person's action based upon that misrepresentation, and you have damages. So you have to meet all of those elements. So basically, okay, you did this. Here are the facts. See exhibit so and so. Right? Right. You knew this because this is your form. See so and so. See exhibit so and so. I did this because you provided me with this. See so and so.
Still not like making it personal.
No. I'm bringing the elements in. I'm not saying you committed fraud.
Gotcha.
You know what I'm saying? And I'm going to let you conclude it because it's your obligation to conclude it. You ain't going to be able to conclude anything else. And here's how I was damaged. Here's how I was damaged. You damaged my standing and reputation in the community. Well, give them a copy of your credit report. They'll be all on your credit report with negative inferences on your credit report. Well, no, I don't mess with things. But I don't. Well, I did it more of this. I just still got paid. You know what I mean? Okay, so, but the key is to make sure you prove all the elements of any claim. So if you're going to make the claim for Title 42, okay, you're going to have to show, okay, you did this without right. Here's what your procedure said.
I personally stayed away from Title 42. I haven't been successful.
Yeah.
So I need to revisit it.
Yeah. You want to revisit it, but you want to get but the key is you want to get the elements. I know what Title 42 you did. It's chock full of conclusions.
Correct.
So I'm going to get it on conclusions all day long. Yes, ma'am.
Okay. I hear what you're saying, but someone here doesn't understand the whole process.
Yes.
Can they come to you for help?
Yeah.
Okay.
Yes.
I think you know the right path.
Right, you want to take your time. You don't want to just delve all into it all at once. You want to learn basic things. Like the Constitution is a good place to start. Constitution, go to the first 10 amendments. That's a real good place to start. The Bible, I have to give y'all some biblical verses now. Because I can just use about 5 biblical verses that if you understand the substance of it, you will attain success in court. If you understand the substance of it. All right? Okay, so here are the verses. Now, the IRS always give you something. They always make claims, right? It's like the brother said, how about the IRS tell them to take this out? They can't verify nothing. We're going to go to Deuteronomy chapter 19, verse 15. It deals with how you verify things. Chapter 19, verse 15. You want to go to 1 Thessalonians. This is one of my favorite ones. First Thessalonians, chapter 5, verse 21. You can do a Google search on that. Prove all things. You go to 5 Matthew, verse 25 through 27. Basically states, agree with your adversary quickly, or you'll be sent to jail. There's a way to do that. He said, agree with your adversary quickly. Agree with your adversary quickly. Yes, sir. Yes, sir. Yes, Matthew chapter 5, verse 25 through 27.
Now, sorry, I have to ask this question.
Absolutely.
What does the Bible have to do with the law?
That's an excellent question. That's the excellent question. American jurisprudence is based on biblical law. You understand the substance of it? I'm not saying that if you get those and you read it, you're going to be able to go to court. No, you have to be able to know the rule, but also the court rules and how those verses apply to the court rules. But then you'll be able to use it and do your thing with it. I beat 2 lawyers up with it. Real simple. I beat them up with Matthew 5, verse 25. Beat them up all day with it. I conditionally accept upon proof of resentment of so-and-so and so-and-so, therefore denied. The judge seen that, took it out the judge's hands. Why? Because I agreed. I said, you get this because we have an agreement. But since you ain't got it, I have to deny it. Well, I agree with him. Oh, yeah, okay. I gave you that 3?
Yeah.
I said 5. I end up giving you out more than 5. Okay. 1 Peter, verse 5. I'm sorry. First Peter, chapter 5. Right? That's 4, right? Mm-hmm. Yeah, 4. Okay. Luke, chapter 11, verse 46. Well, this really gets it. And verse 52. Okay. Now, this is for those that get locked up. Because the 13th Amendment of the Constitution, it allegedly disallows involuntary servitude except when you're arrested for a crime or convicted of a crime, right? But, check this out. The Declaration, I'll write this down. The Declaration of Human Rights, Article 4, explicitly states that slavery in all of its forms are prohibited by law. The Declaration of Rights, Declaration of Human Rights, Declaration of Human Rights, Article 4, states that slavery in all of its forms are prohibited. Yeah, y'all know the United States signed on to that.
Yes, they did.
December 10th, 1948. If I'm stating accurately, precisely. Slavery in all of its forms. Somebody pull up Exodus 21. Somebody pull up Exodus 21:16 and read it for me. Back it up. Anybody got that? Hold on. Let me go to something else first. Hold on. That's good for habeas corpus. Oh, let me go to something else too. So, Declaration. Oh, yeah, that's 3. Okay. Declaration. Yeah, that's 3. Okay. That's Declaration. That's 13th Amendment and Declaration in Exodus 21:16. Anybody got Exodus 21:16 up? Do a Google search on it. Go ahead, read. Hold on. Read it loud. Read it loud. Read it loud.
Exodus 21:16. Anyone who kidnaps someone is to be put to death, whether the victim has been sold or is still in the kidnapper's possession.
Oh,
So that's why they don't want to talk.
So that's why if you're being detained, you're not asking if you're arresting you, you're asking, are you kidnapping me?
yeah. Well, if they arrest you, oh, okay. I had to go to another code because I like to get them. I like to get them tokens. All right. Title 18. Write this down. Title 18, United States Code, subsection 1583. That is enticement to slavery. You don't ask me, are you kidnapping me? Are you enticing me into slavery? And the judge threatened you with contempt? Well, that's the first question I'm asking. Are you enticing me into slavery?
You said Title 18 for
18 United States Code. 18, yes, I'm sorry. 18 United States Code, subsection 1583. 1583. Look at 1581 too, because that could be a misquote. So check out 1581 and 1583. Yes, sir. That's mean too.
So, last week, remember we spoke about the public law 94, I think it was.
What is
The
doing?
one that section 302 that states that at age 18 you're to declare your nationality.
Yeah, that was. Yeah, I did. I read that, and it basically stated that it has to be within 6 months of your 18th, of you turning 18.
Or
That's what it says. Yeah, say that the child that turned 18 or the parent. Is it 83 or 81? Oh, no, you have to. Go ahead.
what you were saying.
Yeah. So yeah. So it was the language. I had to do some more. I had to analyze it a little further.
Right. But the thing is that
Because hold on, because as soon as I heard it, I told the brother. You know what I told the brother? You know what I'm gonna do, right? That's what I told the brother. You know what I'm gonna do, right? Put this declaration together, and they're gonna get that.
but when we nationalize automatically in the declaration,
Yeah.
it automatically states.
Well, we
that.
declare that anyway.
Right, we're declaring it. But the thing is that with some of the things that we just went through,
Yeah.
making those declarations and nationalizing or becoming, if so chosen, becoming a part of ARNA, that automatically pulls you out from under those once you do the proper
Right.
changes
Yeah.
and present the proper paperwork.
Well, we want to operate in our businesses the way they operate.
Right. It's funny because one of the, I know a class that Chief Ali did a couple of weeks ago. He talked about how the Christian names are owned by the Catholic Church.
Yeah.
And so when you're utilizing those names, because they've taken those names and created corporations so that they can get monetary funds for themselves.
Right.
It kind of like leaves us in those jurisdictions where they now can say, hey, you know.
I don't know if they're owned by them or not. I'm not sure. I can't speak on that. But I know we don't own them. I know we don't own them.
Right. If you remember, it was a couple weeks ago, and he talked about how the Christian names are owned by the Catholic Church. Yeah. It's on video. Go back.
Okay, good.
It's on Black Nobel.
Let me show y'all what a revocation of election look like. When I do things, I try to make it as simple as possible. I don't say you violated this or this is so and so. I give the notice. Any disclaimers, I make that. I just go ahead and state the facts. And if anybody can controvert it effectively, get back to me in 30 days by affidavit under paying the penalties of perjury. We might have something here. If not, keep your peace and forever be quiet. All right, this is the sample one. Oh. Oh man, I gotta put this in. It's in PowerPoint. That's the sub. Cut that up. What's up? Hey.
Yes.
You still on phone? You know what I'm trying to do? Can I actually bring the file
This
up?
is why.
Okay, so can I bring this up?
Hold on one second. It was connected. No, the whole time it was.
Yeah, I guess that's when you working with it, just go off.
No, that's normal. You might have hit a function key that stopped it.
Okay, I'll do that. All right. All right, y'all. Here's basic revocation of election. I'm just gonna read it through. Just you can't get it up on the projector. Notice of declaration of revocation of election pursuant to statute and implementing regulation. 26, United States Code, subsection 6013 G4A, by affidavit.
We're going to just have to read it because I'm not sure.
You said you were gonna have to read it. Okay, I'll read it.
I'm not that computer savvy if someone else is. I'm not. I don't know how to work this like that. So. Yeah, but you just have to read. You just have to read it. Yeah, because you hit some button that disconnected.
Okay, cool. Okay. All right, y'all. I'm just gonna basically read a basic revocation of election. All right. Election filing a more tax form and interface with the Internal Revenue Service on a personal level. All right. All right. Here's the title of the document: Notice of Declaration of Revocation of Election pursuant to statute and implementing regulation. Title 26, United States Code, subsection 6013 G4A, by affidavit. You want to do it by affidavit because affidavit is a statement of facts that are stated under the pain and penalty of perjury, and if it's not controverted on public record, it stands as an undisputed fact as a matter of law. This is based on the principle of legal maxim. All right? And if the law is correct, it is considered a self-evident truth. Let me give you another one. Let me give you another legal maxim. Say somebody bought a copy of the contract there, right? And I say the evidentiary law that deals with bringing forth the original document, and I will always use the maxim, legal maxim, that a thing similar is not exactly the same. That's a fact, right? Can't get around that. That's considered legal maxim. So with the affidavit is presented on public record for over 30 days. If it's not undisputed, it is considered an undisputed fact as a matter of law. So we want to learn how to correspond with the affidavit. All right? And if you don't remember the affidavit, just read it out. Read it out in the court. If you're in a court situation, just read the affidavit out. It'll save you a lot of heartache and grief. Yes, sir.
So if they have a copy of it, I understand what you're saying. Obviously, the copy is not the same as the exact.
Yes, sir.
But how exactly does that help? If I'm trying to figure out, like, how does that help? If the copy has the same information, projecting the same confirmation, how does that affect?
Listen, anybody can copy anything. Where you get that from? Where you made that at? Somebody could take your signature and put it on the document. Somebody could have traced it.
So is this all about? I guess we're saying we want to. I guess we're saying the power of that document that they're presenting.
You ain't listen. You come to me. If you come to court against me with a copy of something from something, it ain't coming into court. And if it do come into court, I know what to do with it.
Okay, so
And if the judge allows me to come to court, I'm gonna go to his ball. Object. We rolling now, bro. Bringing the copy. Say no. Objection, Your Honor. Best evidence rule. Pennsylvania Rules of Evidence, Rule 1002 and Rule 1003-1. That rule governs the admissibility of copies. 1002 says got to bring in originals.
okay, that's on that.
No questions asked. 1003-1 states that there is genuine issues regarding the authenticity of the copy. So you better bring that original in, baby. Now, even if the judge overruled, so what? I got it. I preserve my objection. Now I'm prepared for appeal. I'm prepared to go up top on him. So I'm making ready. Court will remand it. So okay, and the judge will respect you a whole lot more when they remand it. You won't have no more problems out of that judge. Right? So that's how you deal with that. And it goes back to 1 Thessalonians 5 verse 21. Basically says prove all things. All right. Oh, also, let me give you this statute. Write this down. Public Law 96. Once I get rolling, y'all. Public Law, Volume 96, Stat 1211. That was passed by Congress back in 1983. That says the Bible is the Word of God. Great. It was passed in October of 1983. As a matter of fact, Congress declared the year of 19. So I'm saying, no, I ain't. Congress stated that 1983 was considered the year of the Bible. All right. When Troy asks, what did the Bible have to do with these laws? According to Congress, Word of God. Great. Got you. I'm bringing God in now. And the lawyers. Oh, woe to you lawyers. Oh, you ain't supposed to be coming here with that nonsense. You supposed to know the law. I'm sorry, public law. Public law is a statute that was passed by Congress. Public law, volume 96. No, yeah, stat. No, the statute. Stat means page number. Yeah, but it's stat though. Just put stat though. That's how it's listed.
Volume 96 stat.
96, stat 12, 11. Yes, sir. All right.
You said it says Congress says
Well, no, they say the Bible is the word of God. I love it. It's beautiful. Then you can bring in Exodus 21:16. Oh, you enslaving me, huh? All right. Put your ass on the death penalty. Excuse my French, but that's what the word said. God said that. I didn't say God said that. What's your word?
I can say, excuse me, y'all, did you swear to tell people the truth so help you God? Lock him up. Next Saturday.
Yeah, I'm
Now I'm out of
there. Hey, let me tell you, ain't no judge or lawyer gonna swear anything on the record.
Yes, sir.
It's not gonna happen. They want you to swear, but they ain't gonna swear to anything.
That's how I do.
Right.
Yeah, I actually
Oh, but check this out though. Oh, there's another maximum law. See, I got me rolling. There's another maximum law that you can use. The maxims are self-evident truths, so it can be used in your memorandums and in your briefs. In the court, it's a legal maxim. It's a legal maxim. Yeah, maximum law, legal maxim. In court, no one is trusted except those sworn. The lawyer don't swear to nothing, so he can't be trusted. I try to use everything with 50 cents, baby. I'm bringing it off. I'm going to make it real simple.
Except those sworn.
Except those sworn. No. It's a legal maxim. It's the legal maxim, which means this is self-evident truth.
Is there a place where you go and get these?
Legal maxim. I don't have it on me, but yeah. If y'all can leave y'all email addresses, I'll have Troy email them to y'all. The legal maxim. It's not all the legal maxims, but it's some legal maxims that are very useful. All right?
What did you just say, Brother Charles? You gonna stand the corner.
All right, let me read this revocation of election, y'all. Because once I get rolling, stuff start coming to me, and I could spare. Absolutely. Okay. Cool. All right. We're gonna read a sample notice of revocation of election. All right. I'll come in with the title: Notice of Declaration of Revocation of Election, pursuant to Statute of Implementing Regulation, Title 26, United States Code, subsection 6013 G4A by affidavit. Then I have I can't get out here. Hold on, Troy, I can't get over here. Can't activate my.
It's not going to. I just read it.
Yeah, I'm saying, but I know it ain't gonna come up there. I'm trying to activate the actual. Okay, I got it now. I'm good now. Okay. So, all right, this is how you do an affidavit, y'all. Comes now. Jane H. Doe, your affiant, being competent to testify and being over the age of majority. At the first, duly verified according to law to tell the truth to the facts related herein. You ain't got to write this down. let me read that again. Thumbs down. Jane Helen Doe, you're affiant, being competent to testify and being over the age of majority. After first duly verifying according to law to tell the truth to the facts, related herein states that she has firsthand knowledge of the facts stated herein and believe these facts to be true to the best of her knowledge. Now, you start stating the facts. Your affiant herein, henceforth and forever, revokes and terminates her sub silentio unknown voluntary election to request her earnings for the use of the United States. Now we're going into the status now. Your affiant is indigenous to the North American continent. Your affiant is an American national. Your affiant does not operate a business in the U.S. Your affiant is a non-resident alien of the U.S. Your affiant is not a resident of the District of Columbia. Your affiant is not a resident of any U.S. possession, territory, or federal enclave. Your affiant is not a federal employee of the U.S. Your affiant never entered into any employment agreement with the U.S. government. The end. Your affiant is mentally competent to make these statements of fact, and your affiant recognizes right from wrong. This is the disclaimer statement. If the statements herein damage anyone, if he, she, or they will inform me by affidavit of facts, your affiant will sincerely make every effort to amend her declaration to suit the truth and the facts. Your affiant hereby and herein reserves the right to amend these and make amendments to this document as necessary in order that the truth may be ascertained and proceedings justly determined. If any opposing parties give a notice by means of this document that have information that will controvert and overcome this declaration, please advise me in written affidavit form in 30 days from receipt hereof, providing me with your counter affidavit, providing me with particularity by stating all requisite actual evidentiary facts and all actual requisite law, and not merely ultimate facts or the conclusions of law, that this declaration is substantially and materially false and made in order to attempt to change my authenticated status. Your silence stands as consent and as implied and tacit approval of the factual declarations herein being established as fact as a matter of law. Further, your affiant saith naught. I'm done. I get it signed, witnessed by the notary. I do it twice. I sign it, get it notarized twice, send it off to the entities, and wait till my green card come back.
Yeah.
I ain't getting to it. What are you saying? I need y'all to read. I need y'all to read that. I need y'all to read that handout. Y'all understand that? Y'all be ready for this. It's only 2 pages. You're not stating a whole lot of law. Matter of fact, you ain't stating no law at all. You're saying I'm not. This is who I am. This is who I'm not. This is what I'm doing. First you statement. This is what I'm doing. I'm broken this BS. This is who I am. This is who I'm not. I'm done. Then I add my disclaimer with regards to the affidavit. Get it signed, notarized, ship it off.
You say you could use notarized twice.
Well, I would do 2 of them. That's what I'm saying. I would do 2 of them. I would do 2 of them.
Oh, I got you.
I would do 2 of them. Yeah. Yes, sir.
Is this in relationship to a proper name change?
You got nothing to do with name change. You got nothing to do with name change.
Okay. Registration. Okay.
Nope.
But you mentioned not needing to be done in English. And you cruise with that.
Now, if you change the status, you had more punch to it. Okay. If you gonna do it right, you can get it done. I don't care if you're nationalized or not.
Oh, okay. That's what I'm asking. You said national.
But yeah, because you got
cleared it.
That's right. You already made the declaration. Okay, yeah, I'm indigenous. I'm indigenous. I'm indigenous to the North American continent. That's who I am. That's what I am.
But you don't have to do that. You have to still state that.
Yeah, you are indigenous to the North American continent.
Okay, right.
For clarity. So let's say I don't know anything about nationality.
Right.
And I want to make this declaration that you just did.
It don't matter.
Do so. It still stands in law. And
Absolutely. Because somebody's going to have to rebut it within a 30-day period by affidavit.
So I take it that Wesley Snipes and them didn't do this.
Of course not.
Because
Yeah,
that's
this
what
was
you always get. You know, that, you guys are going to end up going to jail just like Wesley Snipes and these other people. It's like, yeah, but they didn't follow the process properly.
Was what you just read in here?
No. That's not it. It's definitely not.
That's fair.
It's definitely not.
Don't blow up. You have to stay in the organization. Stay.
Yeah, who I am. This is who I am. This is who I'm not. I'm not a resident of District of Columbia.
Question for
So if you had,
All right. So prior years that are in question,
You're responsible for that.
that you're responsible. So you're just responsible for that.
Here's the way to handle that.
Can you give a brief synopsis on how that could
I
be?
mean, other than through like,
You know you're being recorded, right? So you're eating. I'm just letting you know.
you're a background.
No. You pay them good people their money.
I said what?
You pay them good people their money.
Pay the good people that money.
Right.
Okay.
But there's a way to pay them. They like payment.
Is that who you're? That would not only be to say to IRS, but as far as changing your status and dealing with whomever, rather
No,
not
no,
go
that change
trade.
the status stuff. Yeah, you just change the status.
Well, just claim creditors.
Oh, there's some of these people to deal with.
Okay.
What kind? Debt collectors?
Yeah.
Oh, they.
In reference to what you brought.
Oh, but that's a whole other issue.
Okay.
They ain't got nothing to do with them.
Okay. Got it. Got it.
All right.
Yeah.
Anybody have any more questions? Anybody have any more questions? Yes, sir.
This is, I'm just looking for, I guess, your opinion
Yeah.
and your knowledge. When they say competent background, what enables them to be competent to the subject?
Because they have first-hand knowledge of the facts.
It has to be first-hand knowledge of the facts.
Got to be first-hand knowledge.
That's it.
Now check this out. This scenario. If somebody asks you your birthday, right? You really have first-hand knowledge of your birthday?
No.
Just know it's on the table.
If your mom told you Santa Claus was white, I wouldn't believe
There you go. My mommy told me my birthday was on such and such a date. I mean, they ain't got first-hand knowledge of the facts. So why you asking me that question? Huh? Documentation. What do you mean documentation?
Because when my brother was born, I already had birth certificate or she married birth certificate.
Okay, that's cool. That's cool. But I'm saying, if you don't, yeah, but that means she has first-hand knowledge of the facts. She don't remember when she was born.
No, she don't.
She don't know what you're doing. The feet don't match now.
No, but I'm still saying you document.
That's supposed to be documented. You want to document it. But I'm saying, in actual reality,
No, you don't.
according to the court rules of evidence, it's called the dead man statute. See, I said get rolling. I get rolling.
Come on,
Okay,
come
I'll
on.
write this down. Okay.
Come with it.
Come on with it.
Write
Break
this
it
down.
down.
Okay. Federal rules of evidence. Now, all the states base their rules off the federal rules. So I'd like to use the federal rules because it's common, and but every state rules, the way they lay out their rules, it varies. So Pennsylvania rules of evidence can be section 225. 1002. The state of Maryland rules of evidence is 5-1002. So just like I said, every state varies. But so I like to use the federal rules because every state base their rules off the federal rules. So the dead man statutes are the competency rules. You brought the competencies. I had to do this. Competency rules is based under Federal Rules of Evidence, Rule 601, Rule 602, and Rule 603. All right? A lawyer never has first-hand knowledge of the facts. They can't testify to anything. They like to come in court. They like to talk. You need to know how to object to them. Right.
You said that you said this is dead man statute, competencies under the competency rule.
Yes.
That's the federal rule of evidence.
Federal Rules of Evidence, Rule 601,
So
602, and 603.
603.
Right. That's under Article 6 of the Rules of Evidence. It's comprised of 11 articles. Article 1 is the general provisions. Article 2 is mandatory judicial notice. Article 3 is presumption. Article 4 is relevancy and its limits. Article 5 is privilege. Article 6 is a competency. Article 7 deals with expert testimony. Article 8 deals with hearsay. Article 9 deals with verification and identification. Goes back to Deuteronomy 19:15. You got to verify, you got to get them witnesses, baby. 1 Thessalonians 5 verse 21, prove all things. All right. You got it, slides, I did it? Okay. And Article 10, which deals with documents, photographs, and other things. Article 11 is miscellaneous. So that's how you look up the evidentiary rules. So somebody brings some evidence in court to me, and you don't fall in court with those rules, I'm gonna get in. I'm gonna get on. What's up, bro?
You know, it's interesting. That brings full relevance to the work of the Bible where it says, "Thy word have I hid in my heart, that I might not sin against thee."
Right.
Because now, where you said that in 1983 they declared the Bible the word of God,
Yeah.
and we're dealing with law, and if you hide, meaning that you study and know the word,
Right.
based upon it being now in law, then you now navigate properly because you now utilize the very thing that they've declared to
Right.
be their law.
That's right. God's law.
When you're going back to this point about needing to bring the originals, so if there were a case, and no, let's just say it was a mortgage case, and they were presenting copies of documents allegedly that you signed.
How would you properly object to that? Okay. That's the question?
Yes.
Object.
But no, I'm just verifying
Okay.
the answer because we
Yes, sir.
already had the answer that the documents presented must be original.
No, I'm not going to say that. I'm going to say objection, best evidence rule. Objection, best evidence rule. I'm in Maryland. Maryland Rules of Evidence 5-1002 and Maryland Rule 5-1031. I'm going to shut up. But,
Wouldn't you, if someone asserts something to be a fact, right, and it's a copy that they're trying to authenticate, wouldn't you have to specifically deny
no, you're going to have to
the
deny.
authenticity of that document?
No, but when you object, that's the point. Once you object, it's inadmissible. They can't bring it in. according to the rule. Now, if the judge want to overrule that,
Oh, yeah, that's what I was gonna
that's fine. But you preserve your objection for appeal. You got it on appeal.
No, I got
The
you.
appeals court gonna see that and say, no, that's inadmissible.
Correct.
So once you object, you just go ahead and state the titles under
I'll state the rule that applies.
that apply to that.
Right. Now, sometimes you ain't gonna know the rule, but you object anyway.
Gotcha.
Objection is better than no objection at all. Because if you don't preserve your objection, you're considered not even making the objection. So they'll say, nope, he allowed it. Okay, must be true.
Must be true.
But if you object and they have to figure it out, then then you can tell them, say, no, they said no, that they didn't bring that wasn't the original. That's not mine.
So what I'm looking at technically, they can't put
You gotta do the rule.
yeah, they can't.
You gotta do the
It's not
rule.
I'm just reading over it real quick.
How do you guys rule? Listen, those biblical verses I gave y'all, it was all of the evidentiary rules of court,
Also,
in my opinion.
are there specific? So if you have to have an original, documentation, then I'm assuming that there's rules that these originals.
That is the rule.
No, I'm just saying, like, so how do they define an original? I mean, obviously you can look at something and tell.
The original, yeah, you got to get the blue ink signature. The black ink, the original signature.
No, the only reason I'm saying it because you can print something out. Like if I had someone sign something, you can have it scanned and then you can just print it in color. So it looks
No,
Yeah, it's
I
not
mean, we'll look a little
yeah,
different.
yeah,
I'm just
sure.
trying to I'm just being
I'm
like.
denying. I don't know what you talking about. You gonna bring the original way. I'm going to object.
But then that goes to whatever it is that you're trying to bring forth as evidence.
That's right.
That means the document has to look a certain way. It has to,
It has to be the original.
yeah.
So in other words,
Now, if you did something to it, then okay, you materially altered the document. That's why they don't never really bring it
Yeah,
in.
that's a whole nother.
But
Yeah.
go ahead.
so my mortgage company sold my loan to buyer number A. And buyer A or buyer B, either one of them came at me.
I'm going to kick them in. I'm going to
When I got in well, my mortgage company,
What state you
when
in?
he sold the
What state you
document,
in?
when he
What
signed
state you in?
Pennsylvania,
Philadelphia?
yes.
Okay.
When he sold it, you're saying it's not necessary that they took these original documents and handed them over to collection company number
Allegedly
A
they signed it.
to go after it.
Right. Did they inform you that they signed it?
No. Well, no. Yes, they did. They sent me a notice saying that this new company is going to
Service?
service,
Yeah, that's usually
which is different
usually how
than
they say it.
Okay. I mean,
Okay,
they
It's
own it.
different. The service and whoever's going.
I mean, again, like this now. Title. That says TILA. That's TILA. That's Truth in Lending Act. You got that? TILA. 226.39 A1, 2, and 3. It'll explicitly say that if it's the sign, it'll say that the servicer is not the owner of the mortgage.
Right.
So they come and court and say, we own this note, you can't be the owner. According to
you
that,
can't
according
own
to
it.
TILA is truth. And
TILA, that's Truth in Lending Act.
Right.
That's it. That's an acronym for Truth in Lending Act. It's TILA, TILA. Regulation Z, Z as in zebra, 226.39, A as in apple, then parentheses, 1, 2, and 3 in parentheses.
What was that? I'm sorry. You had the kilo 22639.
No, 0.39. Make sure you get
Oh, 0.39. Sorry.
0.39.
0.39.
A, 1, 2, and 3.
Okay, and then what was that other one you said? Was it the same one? I thought you said something just before that. It was like, maybe I'm
It's the same thing.
okay, well, okay.
Okay. Yes, sir.
Real quick question. All right, so a servicer takes a mortgage that is already in default.
Right.
They go and file foreclosure action,
Right.
and gets a in rem action.
Right.
Based upon what you just shared, they could not have been the mortgagor. They have a mortgagee, excuse me. So if they filed and got it, they illegally represented themselves. because they couldn't be the holder of due course. Am I correct? Or?
That's absolutely true. But check it out. You know, I used to work for the lawyers.
Huh?
I used to work for lawyers. I used to work for a foreclosure attorney.
I know that now.
Right. They never represent the. Right. They have third-party debt collector agreement with the banks. So, you know anybody that invests in stocks and bonds? If you crap out, you just crap out. That's the same thing with those debt collector agreements. If you can get this idiot to pay you again, that's great. If you can't, you just crap out. So they buy the evidence of the debt for pennies on the dollar. And the banks tell them, okay, if you can get this idiot to pay again, this is what I want. And you keep the rest. But it's debt collector agreements that they have with the banks. They don't represent the banks.
And the
So in a
reason you say
circumstance
pay
like-
again is because
So let me give you a rule to deal with that.
What I just asked?
Yeah.
Okay.
Pennsylvania Rules of Civil Procedure, Rule 1002.
Rule of civil procedure.
Pennsylvania Rules of Civil Procedure, Rule 1002. Not Rules of Evidence, Rules of Civil Procedure. It's proof of authority. Show me that you represent this bank. They'll never be able to prove it.
Here's the thing. PA,
That's the SBA though. No,
PA is true.
no, but no, you need to know how to bring
In what manner do you use it?
Man, listen. When I bring it, I keep it very simple. And whenever you file it, you want to always prepare for appeal, because if you're preparing for appeal, it will increase your likelihood of never having to appeal.
I'm just saying, like that carpenter of the deal.
I got to.
I'm very familiar with that.
I kind of like Judge Carpenter. I get
She's
all my stuff.
easier than Padilla.
I get all my stuff from.
Yeah.
I don't have
You
no
gotta talk to
problem.
him, brother.
I have
We
no
need to talk.
I have no problems. Now, in service, I'm going in. Oh, listen. Once you see how simple this is,
I've had success. Don't get me wrong.
Yeah.
You know, I've stopped.
But
Carpenter, I don't know.
But you know,
She replaced Cecily.
oh, really?
Yeah, Cecily was there before her.
Well,
I had more success with Cecily.
Who's that with sister then?
I think she went to criminal or something. I don't know. I'm not doing civil motion.
the good part is though, these type of conversations with the gaps.
Yeah. Good. Any more questions? It's just a knowledge of. It's just a. It's
And
just
how do you, without getting to discovery, you look this stuff up? Like, how do you find those agreements? See what I'm saying? The agreement between the bank.
No. You get it through discovery, but
So you have to get to it.
you have to get a good discovery. But they're gonna never bring it because they don't have it. And if they would bring it, if they bring it, it's gonna show that they have authority to represent the bank.
I had a judge, this was in Jersey. I had a judge tell me at a hearing, well, I'm making a ruling and finding that they have authority to foreclose. I was like, based on what evidence?
Yeah.
She was like, I find that they have authority.
But you had to be
I'm
prepared to
appealing
do
it. Obviously, I objected. I'm appealing it.
Right.
But all I'm saying is, like, usually on that, like, the common pleas level, that don't work.
See, they banking on the fact that you don't know how to appeal. But if you telegraph to them, I'm going to appeal. Here's what I'm going to use to appeal, and you ain't going to be able to overcome it. As a matter of fact, this is our chapter. Once I get going, because we go back a little bit. When I was a little boy, so let's go back this quick. Come on. My elders, you can verify. I know where it come from, but it come. They will ask you questions like, when is their birthday? When is his birthday? And I would just recite it. They just tell me once, and I'll just remember it. It's extra. Do that. Just do it. Do that. It's his birthday. When am I even? Stuff comes to me. Once I read it and go through it, it comes. And, you know, I was always considered hard-headed. I was considered hard-headed. But I knew a little too much for my own good at times. You know what I'm saying? But this court stuff, oh, I'm dug in now. And I would challenge them. Get the best legal mind you have. To challenge me on everything that I file, and I will make them look silly. I'm a challenge right now. Bring forth the best legal mind. Here's the law. I'm going to deal with it properly. Because you probably already know, they do nothing but make conclusions. I beat them on that all day long. I beat them up on that. I beat them up mercifully on that. All right, now I'm going to my train of thought. It was, oh yeah, okay, yeah. So he's done with the court. So, but you just need to, be aware of the rule. You don't want to make no conclusions. You don't want to tell them what they violated. You want to state what they did to show how they violated. Okay, you did this. Here's the evidence. You did that. 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 Here's the evidence. Here's my affidavit in support. Under the pain the penalty of the perjury. I'm swearing to this. I'm verifying this. Under the pain the penalty of the perjury. Now get somebody else to do the same. As a matter of fact, I'm willing to pay the ultimate price for it. Show me the other party that's willing to do the same. I'm standing on the basis of truth. I know you come with lies. Ain't the best you got. Yes, yeah. Absolutely. That's all I got. Truth, nothing else.
Appreciate everybody. How many of you got something from that today? All right. This is what we work toward each week, is to make sure that we're bringing forth information that will assist you in growing forward in your natural life, in the right now, real time. Because so many times you hear information and it's so aloof. It's like, how does that deal with me? How do I deal with it presently? How do I apply it to my present day life? You guys can apply that to your present day, am I correct? Or at least have